Hello, my true crime lovelies. I hope you are well. I hope you are as lovely in life as you are in my mind. It's the last day of April. And if April is the month of fools, we should not be surprised that Sarah has entered one more thing for the month of April on the family docket. It's not what you think. And it's not what she's supposed to file, but when is it ever? We're going to get into all of it. I've got the long and the short. I'm going to start with the short for those of you guys who have a short attention span, and I'm going to then go on to the long for those of you who like to be nosy like me. But first, let me thank all of my members. Hey y'all, this is editing me coming in for a real quick fix. For some reason, I missed the beginning of this. All right, so this is sent by Sarah on the 28th of April from her correctional institute in the annex. She's transposed this here. She's got it Sarah Boone v. Brian Boone, even though she is the respondent and he is the petitioner. It's all about control. I want to be the one in control, said Sarah. Dear Mr. Martell, enclosed, please find petitioner's first set of interrogatories directed to respondent, Brian Boone. Sir, pursuant to Florida Family Law Rules of Procedure 12.340, given the pending discovery cutoff date of May 28, 2025, we respectfully request that your client respond within 14 days of service. Failure to comply or fully respond may result in a motion to compel and a request for sanctions. Thank you for your cooperation. Sincerely, Sarah K. Boone. 1. Identify all sources of income you have received from any person, business, or entity from February 25th, 2020, the date of respondent's incarceration, and when petitioner stopped paying alimony. So she's super tit for tat. In his document, he says this, the date of respondent's incarceration. So she repeats it and then adds, and when petitioner stopped paying alimony, which is kind of redundant because he stopped it because that's when she was incarcerated. But okay, Sarah. Point. So including to the present, including but not limited to employment, self-employment, gifts, or family support. This is none of her business. He never claimed indigency as to why he couldn't pay her. He said she was no longer entitled to it because she murdered someone. So what his income is, and to be fair, he already submitted his affidavit of his financial disclosure. So maybe they crossed in cyberspace, but his source of income is none of her business, has nothing to do with anything. State the name, address, and nature of all employers, including self-employment and contracted work. So he's a developer, software developer. They do a lot of contract work from February 25th to present, and your monthly and your gross monthly income from each. Why does she need to know the nature? Like if he's pole dancing, she's going to shame him or what? Like, I don't understand why she needs to know the nature of all employers. But she's not entitled to any of this information. Describe in detail any financial assistance, gifts, loans, or monetary support you have received from any family member, friend, or third party, like a girlfriend, Sarah, from Feb 25th, 2020 to present, including amount, frequency, and purpose of such assistance. Maybe just because they love him. But with her, she's going to designate, like if she's gifting, quote unquote, gifting someone, she's going to say what the purpose is. And I guess if they deviate from that, they owe her the gift back. Y'all let me know. Identify all bank accounts, investment accounts, digital wallets, or other financial accounts in your name or under your control from February 25th, 2020 to the present, the name of the institution, account type, and current balances. None of your business. Kick rocks. Like, is she going to call each place to verify that? And digital wallets. Is he into crypto? What is that all about? Describe any and all sources of financial assistance, employment, or income you expect to receive in the next 6 months. Pound sand. Sarah, what does that have to do with anything? Technically now, the alimony has told as of April, and maybe because she wants to show proof that he can pay her $61,000. I don't understand why she's asking that. I think it's all about control. All right, back to your regularly scheduled programming. So I think this is all a Sarah control thing. She's like all up in his pocketbook for no reason. So whatever he received in the income he had in the last 6 months, whatever work he's doing from home and the nature of it, why would she need to know that if she's after the money? Like, are you judging him? Like, do you think he's like a cam girl or cam guy right now from home and that's how he's making, like, where are you going with this, Sarah? List all real or personal property, cars, homes, investments. So these crossed in the interwebs because he already sent in his certification of financial data. He's listed his home, his car, all that on there. We talked about that. He got a 2018 Kia, I think before he had a Prius. Where is she going with this? She wants him to sell his only car that he uses to get their child around to help her buy honey buns in prison. Like, girl, if you don't get it all the way together. Owned by you individually or jointly, I'm guessing she means like his parents, with others from February 25th, 2020 to the present, including approximate value and location. Why does she need to know the location of his home, the location of his car, the location of his investments or valuables? Are you sending somebody who just got out of prison after him? Because you sound dangerous, ma'am. Identify all debts or liabilities you currently owe, including creditor names, amounts owed, and monthly payments. Why is that any of her business? On a financial statement, I don't think you even have to put on there your creditors' names. Like, is she going to call them to verify it? It just seems excessive. Identify any cash, gifts, or inheritances you have received from the date of her incarceration to present, including date, source, and amount. I don't even think she has any standing to ask for these things. And so when she's saying like she will, if it's not answered, she'll look to the court for sanctions. On what grounds is she asking? She gives no case law that would compel him to turn these over, but we'll see. Maybe because it's under the guise of interrogatory, she feels like he has to. So then this letter, Dear Mr. Martell, pursuant to the applicable discovery rules, please accept this letter as formal request for production of documents, which I think you need to do a subpoena ducis tecum if you want these documents. You don't just write like a correspondence and copy the judge on it, copy the court. We respectfully request, and again with the we, your client, Brian Boone, produce the following within the time frames allowed under the rules. All documents related to any income earned by Brian Boone from February 25th, 2020 to present, including but not limited to pay stubs, 1099s, W-2s, and tax returns. So if she has the tax returns, she does not need the pay stubs, the 1099s, and the W-2s. All of that data would be included in the tax return. And if she looked at the document that he sent, he didn't file a tax return since 2022. Why she's going completely back to her date of her incarceration, he keeps saying because that's the day he stopped paying. But he never said he stopped paying because he was indigent or was having a financial issue. He said because she killed someone, she wasn't entitled to it. So what he made, if he made $10 million, has nothing to do with her. All closing statements, settlement sheets, and bank records related to the sale of the former marital residence. None of her business. She conveyed all of her rights over to him. She signed a quitclaim. In fact, I'm going to show you this. He paid her $10,000 to sign the quitclaim. So whatever he did with that house, if he set it on fire and collected the insurance, is his business. Well, him and the insurance company, but you know what I mean. It's like, Ma'am, if you don't get your life together. Oh, this also, I want to show you guys lump sum payment for equitable distribution. So the things that they own jointly, he paid her $22,000 for, which was one half of her outstanding credit card balances. They divided up all personal property. She was meant to collect her things from the marital home within 14 days from the date of the agreement, which was in 2018. Retirement, they each agreed to keep their own 401k, IRA, whatever they had, they kept. They agreed not to divide it. Because I know in one of the documents she sent, they were saying her alimony was so high because she gave up all these other things. So point by point, she has been compensated for everything they had during the marriage, right? So here, husband shall pay to the wife the sum of $10,000, which represents the wife's equity in the marital home. Said sum shall be paid within 30 days. It doesn't say in here that she's only taking $10,000 so she can get more alimony, which if she did that, she would be a fool. Like if you have $50,000 in equity in the home and you agree to 10,000, you're an idiot. You know what I mean? Like make it make sense, Sarah. And then it says wife transfers to husband her interest in the escrow account, if any, with the mortgage company. She is not responsible for any shortages, nor does she have a claim to any excess on that amount. So if when he sold the home in 2023, the equity had gone up like notably, remarkably, she's not entitled to anything from there. This is specifically talking about the escrow account, but I'm just saying in general, she was already paid out for the equity in the home, right? Any equity that accrued after the divorce, it's all Brian. Wife assigns to husband her interest in the homeowner's insurance policy. All I can say is balls of a burglar to ask for all of this information and it have nothing to do with her, have nothing to do with their original settlement. All records of financial gifts, loans, or support received from any family members or third parties. So again, I think she's coming after, like, did his family give him any money and he's not claiming it, or maybe he's kind of claiming it. I don't know. But he never said he's stopped paying her because he didn't have the money. He mentioned in his relocation that he was unemployed and would like to move closer to his family, and that part of the request, and that was granted, which makes sense. He didn't have a job. He still doesn't have a job. He's closer to his family. It's better for his son. There was no reason for them to stay in where they were in the prior location because she was in jail. It didn't matter where they went, basically. All bank statements, investment account statements, financial account records for accounts held individually or jointly within the past 5 years. Why, Sarah? Why is that any of your business? Any communication regarding employment or remote work arrangements since February 25th, 2020. All records reflecting monthly expenses paid by third parties on behalf of Brian Boone. So really, like if he paid Con Ed or whatever the utility place is in Florida, if his mom paid that, she wants those expenses documented. Why? This man is taking care of your son because you were in prison for murdering your boyfriend and you're mad because somebody is helping him out. It benefits your son. Please provide these documents within 14 days of the date of this request. If your client fails to produce these documents, we, the ubiquitous we, reserve the right to seek appropriate relief from the court, including but not limited to a motion to compel and an award of attorney's fees and costs. Ma'am, you don't even have an attorney. Who, and she signs it respectfully, Sarah K. Boone. Is she asking, like, as if she's the attorney for attorney's fees and costs? The whole reason we're here is because she wouldn't sign a joint stipulation. So if he wins his motion, she's going to have to pay for his attorney. So keep writing him letters, girl. Run up that bill. This is their order for the alimony and the child support. Support for the child. It was $100 a month. It was based on their co-parenting arrangement, right? Since she's in jail, she obviously is not supporting the child in any way, so she has no need for child support. And in fact, the reverse is true because now he's a single parent. She owes him child support. And then we've got durational alimony. So in the original order, the alimony amount is modifiable upon a showing of a substantial change in circumstances, but the duration cannot be extended for any reason. So it was for 84 months. It was meant to end this month in April. So it can be, I think her going to jail and then to prison is a substantial change in circumstances. In the event of the modification of the amount of the alimony payments shall be based on the tax law in effect prior to the tax cuts. There's the real property. We talked about that. Then let's look at, this is his petition for modification. Termination of child support. Former wife does not incur any expenses for the minor child and as such is not entitled to child support. The termination of child support should be retroactive to February 25th, 2020. Noticeably absent in her snarky correspondence was she didn't ask how much he incurred in supporting the child. She mentioned nothing about the child whatsoever. All it is like, what did she say? George's wife said,
give me money, give me money. She's like, show me money, show me money, show me money.
She doesn't say like, what are you spending on the child? What does your life look like, as a single parent? The former wife does not incur any expenses for the minor child. The former wife would not sign the joint stipulation, so that's why he's asking for attorney's fees in this. She wouldn't sign that. And then after she wouldn't sign that, they were supposed to have mediation. She refused to even discuss a date for mediation. So he's asking for the sole care and custody of the minor child, as well as 100% time sharing and decision making. Terminate the former husband's alimony obligation to the former wife, retroactive to Feb 25th, or in the alternatives, suspend all payments during the former wife's incarceration, so that would be indefinitely. Terminate the former husband's child support obligation, retroactive to February 25th. And it has been suspended since then, and it was like based on her, I'll show you that in a second, based on her incarceration. So he's not being billed for the child support. It's just they need an official end now that she's been convicted, which is why the Michael Dean, the former family court judge before we got Miss Jackson, said, we'll look at all of this after her criminal matter is resolved. And then order the former wife to pay the former husband's reasonable attorney's fees and costs necessitated by her actions. And then they sign that. And this is why I feel like Brian is a decent guy, because he could have said she should be paying me child support. He didn't. But I mean, he is a single parent and she's still alive and she gets money in there. She's got the documentary people buying her Zuzus and Wham Wham. She's got her fans buying God knows what. Yeah. I saw this and I was like, she's not abiding by any of this. This is part of the parenting plan. And we went over this. I have got 3 Boone v. Boone, part 1, 2, and 3 with the documents. Part 1 has all of the documents. I go into each thing in great detail. But this one, the child has the right to be a child, to be free from parents' guilt and not to assume adult or parent roles. So that's not going to bode well for the text messages that she sent to him, like, man up, and telling him, like, actually, she said, man the F up, and hanging up on him on the telephone and then reciting it to other people that she hung up on her son on the telephone because her feelings were hurt. He's a child and she's taking that away, and the guilt is off the charts with this woman. Information sharing. So notwithstanding the above, each parent shall be responsible for obtaining records and reports directly from the school and healthcare providers. So she's accused him of withholding information regarding the child in school, and like when he was seeing a counselor, a mental health counselor, for being bullied before they moved. It says right here, she's responsible for obtaining the records. She's in jail, or now prison, of her own volition. So the fact that there's extra hoops to jump through is not Brian's fault. You don't then shift the burden to him of like, oh, well, she was irresponsible and killed her boyfriend and created a snuff film, so now you have to do extra work to compensate for her irresponsibility. Like, where do they do that at? Both parents shall have equal and independent authority to confer with the child's school. So yes, she can do all of that. Collect. I mean, that's where she is. This I wanted to share. So this was, Sarah had filed for contempt of court because Brian was not paying the alimony. But the judge said, well, Brian's attorney came back and cited case law of like, he can't be in contempt until his motion is heard, and he can't be forced to pay, right? Because then that would be holding him in contempt until his motion is heard. So Mr. Martell asked for a notice for trial, like, let's get this on the road. And that's when Judge Dean was like, we're not going to go to trial on this until after this other situation is resolved with her criminal case. But he did say, and Mendoza filled in for him, substituted counsel for him that day, will provide an order to the court regarding any child support being vacated temporarily. This will be solely based on Miss Boone's incarceration. And then it says she completed a change of address form. Speaking of that, she hasn't completed a change of address form now, and her stuff is going to the wrong, like she's in the annex, and she's filing all these other things, but not the change of address. But don't worry, it'll be somebody else's fault because it's never Sarah's fault. All right, lastly, for the very nosy, I made this document, Boone v. Boone family court dates. So April 26th, the updated mandatory disclosures were due. Did Sarah turn them in? No. They're currently 5 days late as I record this on April 30th. The updated mandatory disclosures, Brian did turn them in. We went over them in the last video. That's where we know he hasn't had a job since it would have been 2021, I guess, because 22, 23, 24, no job, no tax return. So they have this, they are meant to have a meeting by tomorrow and send the results of that meeting to Judge Jackson. It's settle any unresolved issues that they can settle. Sarah is never agreeable to anything, so she's not going to settle. She's going to ask a million questions and swear she's looking for solutions. Agree of the evidence handling, so what is going to be included, what one side wants included and the other side doesn't want included. They're going to write on little tags and say why they don't want it. And then they have to have a document, each of them, like an exhaustive list of everything of like, this is what's coming in, this is what's not coming in, this is why I want it in. They refused. They're going to review their witness list. I will not be surprised if Christina Pena, possibly Lana are on that list. I think it'll be easier. Well, I don't know where Christina is currently, but she was in Florida. They have to find her, but I'm sure a private investigator could locate both of those ladies. Perhaps even Peter, now that we know a little more about him, might be a witness. So child support guidelines. So Brian said he was definitely filing an updated one. Sarah should be looking at that, or her flying monkey should help her out. Discuss stipulated facts. So if there are things that they don't need to argue, they both agree, you can't see this, but like, this is a hand. You agree that's a hand? Oh yeah, I agree. Me too. Sign it. There's a hand. You don't have to show foundation and everything else. So you have that entered into evidence, and that helps speed things up, or entered into the trial. That helps just keep the trial nice and tight and succinct. And then attorney's fees they're meant to talk about. I don't know how Sarah could pay, but she could be held accountable for it. And so certificate of compliance, that is due next Monday, May 5th. Brian has already turned his in. We went over it in the last video. Sarah has not. She has until Monday. New financial affidavit will be due on the 20th from both of them. Brian has already submitted his, but I guess if anything changes while they go through their documentation and the stipulation agreement, it could change based on that. Joint pretrial statement. So this one is interesting. If they can't agree, they have to do their own statement. I feel like that is what's going to happen. I just don't see Sarah agreeing to anything. For whatever reason, she's on her revenge tour. It must be like a narc thing. Not that I'm diagnosing her, but she was diagnosed with traits liken that unto a narc, as Kathy would say, from gossip, rumor, and innuendo. And then motions cutoff is also May 22nd. So any motions in limine of like what can and can't come in, any other motions, they all have to be done on the 22nd. And Judge Jackson was very specific. There won't be exceptions. It will have to be taken up by the court to even hear if it might come in, but like as a blanket rule, no exceptions. And then their discovery deadline is the day before their pretrial conference. So the conference is on the 29th. Their discovery is due on the 28th. What do you guys think Sarah will have in? Hopefully you guys saw that. It says my browser lost. We'll see when I edit this. I might end up doing this again. But who do you think Sarah will have as witnesses? Has she even thought about that? What will she have as evidence? She's like gung-ho about these documents, but the documents are not in her favor. There was one just really fast. Let's see if I had it pulled up, where it was like not to harass them. And I was like, well, that's already failed in one of these marital settlement docs. Let's see. Oh yeah, here we go. Behavior. What does that say, y'all? Neither party shall annoy, threaten, or otherwise interfere with the other party. If having your ex-jail cellie, bunkie, call your husband and tell him to put money on your books is not harassment, I don't know what is. The threats, all of it, it's just like off the charts. So that's in the marital settlement. The documents are not in her favor. She wasn't following the parenting plan. She's been bullying her son. I just don't know what planet she's on. We should ask her what color the sky is. Is it red? Is she on Mars? Like, what's happening, Sarah? So let me know your thoughts. I'll talk to you guys in the comments. Are we surprised? Talk to you later. Toodles.